Welcome to Chapter 4 of Medical Law and Ethics, Law, the Courts, and Contracts. Throughout this chapter, we will cover the following learning outcomes. We'll discuss the basis and primary sources of law, identify the classifications of law, define the concept of torts and how the tort of negligence affects healthcare, list the 4 essential elements of a contract, and differentiate between expressed contracts and implied contracts, and compare the contractual rights and responsibilities of both physicians and patients. Here's a list of the key terms we will cover in this chapter. To begin, we'll do a brief review of the sources of law inside of the federal government. The federal government is comprised of 3 branches of government. They're legislative, executive, and judicial. The 2 houses of Congress make up the legislative branch of government. This includes the Senate and the House of Representatives. The Senate is made up of 100 members, 2 from each state, and they are elected for 6-year terms. The House of Representatives, on the other hand, has 435 seats, and they are elected for 2-year terms. Their representation from each state is based on the population. The primary duty of Congress is to write, debate, and pass bills, which are then passed on to the President for approval. Other powers of Congress include making laws controlling trade between states and between the United States and other countries, making laws about taxes and borrowing money, approving the printing of money, and declaring war on other countries. The executive branch of government, otherwise known as the President, is responsible for administering the law through his or her ability to issue executive orders. An executive order is a rule or regulation issued by the President of the United States that becomes law without the prior approval of Congress. They are usually issued for one of 3 purposes: to create administrative agencies, to change the practice of an existing agency, or to enforce laws passed by Congress or make treaties with foreign powers. Lastly, the judicial branch of government, or the Supreme Court, but also includes federal judges and courts in every state. They are there to interpret the law and oversee the enforcement of laws. The division of powers and responsibilities among the 3 branches of government ensures a system of checks and balances that will keep any one branch from assuming too much power. The state government is designed very much like the federal government with 3 branches of power: legislative, executive, and judicial. The legislative branch still consists of 2 chambers, the Senate and the House of Representatives, but differs from the federal government in that the number of legislators is defined by the number of districts inside of the state, and the term length is not always the same. They deal with responsibilities not governed by the federal government. While each state has its own constitution, the state constitution cannot conflict with the U.S. Constitution. The executive branch of state government is headed by the governor, and the judicial branch is the courts that oversee state laws, and the highest court in the state is also the Supreme Court, or the state Supreme Court. Both the federal and state courts deal with 5 types of law, the first of which is constitutional and is based on either the U.S. or state constitutions. Secondly is case law. Case law is set by legal precedent. Case law began with common law, which is the body of unwritten law developed in England. In the early days of America, laws were derived from those originating in England. Often they weren't written down, They were more based on customs and traditions of the people. As judges shared their decisions with each other, these decisions became common law. As time passed, court decisions began to be written down, and judges could refer back to these previous cases and help them make current decisions. These written cases were then defined as legal precedents, which is now what defines case law. Today, legal precedents are the rule of law applying to future cases even though they were not enacted by legislation. Precedents can only be changed by the original court that decided a case or by a higher court through appeals. Statutory laws are laws passed by the U.S. Congress or state legislatures. These laws begin as a bill, and as they pass through the two houses of Congress, may become laws. Then a president or governor can veto them, or they will become a statute. And lastly, administrative laws, which have been enacted to define specific agency powers when new agencies are created. These regulations may be passed that pertain specifically to the functions of a single agency, such as the IRS, Social Security, or the Occupational Safety and Health Administration. After laws have been created through constitutional, case, statutory, administrative, or common law, they are classified by type. The two broad types of law are substantive and procedural. Substantive law defines and regulates the legal rights and obligations. It defines the relationships between people and the state, and is further broken down into categories such as criminal, civil, military, and international law. Procedural law, on the other hand, defines the rules used to enforce substantive law. For example, the Miranda warning, or the laws that require police to read suspects their rights and govern the arrest and trial procedures, are all examples of procedural laws. Crimes normally land in one of two categories, either criminal or civil. I'm going to begin with civil. Civil law does not involve crimes against the state, but instead involves crimes against people. Under civil law, people can sue one another, a business, or a government. There are usually disputes over contract violations, slander, libel, trespassing, product liability, automobile accidents, and then other civil suits can be family matters such as divorce, child support, child custody. Judgments in civil cases often result in a payment of a sum of money to the injured party. Criminal law, on the other hand, is laws involving crimes against the state. The state will have laws against things like murder, burglary, robbery, arson, rape, larceny, practicing medicine without a license. In these cases, when the law is broken, it is a violation against a public law forbidding or commanding it. Therefore, charges will be brought by the state against the alleged offender. Crimes are classified then as either felonies or misdemeanors. Felony is a crime punishable by death or by imprisonment for longer than 1 year. They tend to be more serious crimes, things like abuse, arson, burglary, conspiracy, embezzlement, fraud, drug dealing, grand larceny, manslaughter, murder, mayhem, attempted murder, rape, robbery, practicing medicine without a license. Misdemeanors are lesser crimes and are punishable by fines or imprisonment in a facility other than a prison for less than 1 year. These can be things such as traffic violations, attempted burglary, disturbing the peace, or thefts under a certain dollar amount. Civil law includes a general category of law known as torts. Civil law includes a general category of law known as torts. A tort is a civil wrong committed against a person or property, excluding breach of contract. The act, which is committed without just cause, must involve injury, damage to the property, or deprivation of civil liberties. Torts can be intentional or unintentional. The injured party can be financially compensated for any harm done by the tortfeasor or the person guilty of committing the tort. Here's a list of intentional torts. The first two, a lot of people seem to be confused of which is which because they are always said in combination. It's always assault and battery. I always try to think of it this way. Assault is threatening someone, threatening to hit them with something, threatening to hurt them, threatening physical harm. And battery is more like if you were to hit them with the bat. So if you are going to hit them with the bat and you do, that would be battery. If you threaten to do it, that would be assault. Conversion is the unauthorized borrowing of something of yours. So if somebody comes to your house, takes something of yours, uses it, and brings it back. Deceit is a false statement or deceptive practice done with the intent to injure someone. Defamation, speaking bad about someone. False imprisonment is the unlawful restraint of a person, whether in prison or otherwise. Fraud, dishonest or deceitful practices, trying to deprive someone of his or her rights. Infliction of emotional abuse, purposefully hurting someone, intentionally or recklessly causing emotional or mental suffering to another person. Interference in contractual relations, so causing one person to break a contract with another or to never enter into that contract with another. Invasion of privacy, interference with a person's right to be left alone. Misuse of legal procedure, bringing legal action with malice and without probable cause. So you're bringing someone to court just because you're angry at them. Nuisance, anything that interferes with the enjoyment of life or of your property. And trespassing, wrongful injury to or the interference with the property of another. Essentially, if you're somewhere you're not supposed to be. Unintentional torts. These are the ones most common seen within the healthcare system. And unintentional torts are acts that are not intended to cause harm, but are committed unreasonably or with a disregard for the consequences. In legal terms, this constitutes negligence. Negligence is charged when a healthcare practitioner fails to exercise ordinary care and a patient is injured. Simple phrases like, "I didn't intend to do it," or "I should have known better," best describes a negligent act. Negligence can also be charged to an institution. The question to ask would be, what would or could a reasonably careful hospital do under similar circumstances? If it would be a different answer, then negligence could exist. A hospital can be held liable for medical malpractice if negligence conducted by its agents or employees or its own institutional negligence can be proven. According to legal experts, a hospital owes its patients a duty to exercise a reasonable degree of care when dealing with apparent risks. Various types of evidence are useful in establishing a hospital's standards, including expert testimony, existing federal and state laws, hospital bylaws, customs and community practice, and accreditation standards. While expert testimony is typically required in malpractice cases, sometimes institutional negligence can be established without that testimony. Type of court that tries a case is dependent upon the state or federal crime that was allegedly committed. The federal court system hears cases involving federal matters, and the state court systems, independent of one another, generally decide cases involving matters occurring within their own state borders. Jurisdiction is the power of a court to hear and decide a case before it. Federal courts have jurisdiction over federal laws such as antitrust, federal crimes, patents, and fraud in Medicare and Medicaid. State courts, where each state has its own court system, but the general structure is the same. The bottom tier is local courts, then trial courts, appellate courts, and finally the state Supreme Court. As with the federal court system, there is also some special state courts with jurisdiction over just certain types of cases. Your players in the courtroom scene are the plaintiff, or the person bringing charges in the lawsuit. This person must show that he or she was wronged or injured. The prosecution is the government acting as the plaintiff in criminal cases. And your defendant is the individual who is charged with the offense and must dispute the complaint. Moving on to the essential elements of a contract. A contract is a voluntary agreement between two parties in which specific promises are made for consideration. In order for a contract to be legally binding, these four elements must be present. First of all, an agreement. So one party makes an offer and the other accepts it. But in order for this agreement to be valid, it has to relate to the present or to the future. It must be communicated or written down. It must be made in good faith, not under duress, not as a joke. It must be clear enough and specific enough to be understood by both parties. And it must define what both parties will do if the offer is accepted. Secondly, consideration. Something of value, usually money, but something of value is bargained for as part of the agreement. If the contract is fulfilled, then the money or consideration must be paid. Legal subject matter. In order for the contract to be legally binding, the items discussed must be legally obtainable. The individuals must be legally able to perform the acts discussed. If a physician was not duly licensed to practice medicine and entered into a contract with a patient, that contract would be null and void or not legally enforceable, because the physician was not licensed to do the things he agreed to do. And lastly, contractual capacity. Both of the parties entering into the agreement must be capable of fully understanding all of its terms and conditions. Therefore, a mentally incompetent person, somebody who's insane, in a drug-altered state, drunk, under some sort of duress, are considered incapable of entering into a contract. If either of the concerned parties is incompetent at the time it's made, the agreement will probably be declared void and would have to be reevaluated or validated at a later date. If all four elements are present and the contract is legally enforceable, but one of the parties fails to comply with the terms of the contract, it would be considered a breach of contract, and that party could be charged with breach of contract. And lastly, a minor cannot enter into any sort of contract without the consent of a parent or legal guardian. A minor is usually defined as anyone under the age of 18, but in some jurisdictions, 21. There are two main types of contracts: expressed contracts and implied contracts. Express contracts may be written or oral, and they're an agreement in which all of the terms of the contract are explicitly stated. Implied contracts are unspoken, and their terms are usually the result of the actions of the parties involved. A physician may seek to terminate the contract between himself and the patient for things like failure to pay for services or failure to keep appointments. To protect the physician from charges of abandonment, though, all missed appointments should be noted on the patient's chart. Also, failure to follow the physician's instructions. And it doesn't seem to matter if the failure is due to the patient's willfulness to follow those instructions or from negligence, not taking their medications, not following through with the things he has asked them to do. And lastly, if the patient seeks the services of another physician and the patient acknowledges this, either orally or in writing, then the physician can terminate that relationship. The proper procedure, though, is to document this on both the patient's chart and send a certified letter and put a copy of that letter in with the patient's records. Seeking a second opinion, though, is not grounds for terminating the physician-patient relationship. There are a few laws governing the payment of fees for service in healthcare, the first of which is third-party payer contract. In this, a third party or a different person is willing to pay for services rendered to another. Such contracts must be in writing before healthcare services are rendered in order for them to be enforced. The Fair Debt Collection Practices Act of 1978 requires debt collectors and creditors to treat debtors fairly. It ensures this fair treatment by prohibiting methods of debt collection. These things include harassment, misrepresentation, threats, handing out false information about the debtor, or engaging in unfair or illegal practices in attempts to collect this debt. Personal, family, and household debts are all covered underneath this act, and it includes money owed for things like the purchase of an automobile, medical care, and charge accounts. Implied contracts. In healthcare, there are a lot of implied contracts. When you go to the doctor trying to seek treatment for an illness, and the doctor agrees to see you, he does not literally have to say, I am offering my services to treat you for X dollar amounts. You are seeking his services, and he is willing to see you. You are implying that you are willing to pay to be seen, and he is implying that he is willing to see you in order to be paid. Because both sides of this contract have the same goals in mind, the implied contract is valid and enforceable. Another situation in healthcare is emergency care. You come to the emergency room after a car accident and the doctor treats you. They are expecting you to pay for such care, and you are expecting to be treated without first having to sign contracts. Managed care plan contracts have added another element to the physician-patient relationship. Physicians still have contracts with their patients, but they may have also contracted with a managed care plan to provide services for a certain fee. If the physician terminates his contract with the managed care plan, this doesn't mean that he can no longer see the patients of that care plan. It just would likely mean that that care plan will no longer agree to pay for services with that physician. Inside of the physician-patient relationship, each party has certain rights. The rights of the physician is to make reasonable limitations on that physician-patient relationship, to set up a practice based on his or her credentials. For example, a podiatrist would not see you for a sore throat or a stuffy nose. They also have the right to set up an office and determine the hours they're willing to work it, to specialize, and to decide which services they will provide and how those services will be provided. Patients also have certain rights. They have the right to considerate and respectful care, information on the diagnosis, treatment, and prognosis of their situation. They have the right to receive enough information to give informed consent, both the good and bad sides of treatments, procedures, etc. They have the right to refuse treatment, the right to confidentiality, the right to a continuity of care, the same doctor following their case to its completion. They also have the right to a knowledge of hospital rules. According to studies, the 3 types of patients most likely to leave a hospital AMA or against medical advice are those worried about paying the medical bills, those with alcohol or substance abuse problems, and those who have had a previous discharge against medical advice. So if they have left AMA before, they are prone to leave AMA again. After seeking a doctor's care, the implied duties of a patient are to follow physician instructions and cooperate as much as possible. They need to give all of the relevant information to the physician. They need to share all of their symptoms, problems. That way the physician is more likely to reach a correct diagnosis. If they do not share all relevant information and the physician forms an improper diagnosis, the physician will not be held liable. They need to follow physician's orders for treatment. If the patient willfully or negligently fails to follow the physician's instructions, that patient has little legal recourse if they do not get better or get worse. And lastly, they need to pay the fees charged for the services rendered. Thank you for joining me for Chapter 4 of Medical Law and Ethics, the Law, Courts, and Contracts.